Hello, my name is Kedge and I am the Director of the McKenzie Friend UK Network. I'm a retired police chief inspector. And I've been a McKenzie Friend since 2012 and all my blogs, my views and opinions are entirely my own. I have a lot of people contacting me about child arrangements with their own experiences of solicitors, and very commonly people say to me three things. That they found that their solicitors charge thousands of pounds in completely unnecessary work, that in any event the solicitors' fees are extortionate, and that they appear to stir the pot of hatred and acrimony with the belief that is often for nothing more than financial gain. So I've looked at the government website, the Court and Tribunal Service, on the guide to child arrangements and also the child arrangements programme flowchart that they provide. And nowhere does it say that you need or should get a solicitor for child arrangements going through court. The first question I ask you is whether there's dispute over arrangements for children. And if there is, they tell you to attend a MIAM, a mediation information assessment meeting, to see whether mediation will be suitable and hopefully successful. What it doesn't say is go and get a solicitor. It tells you to try and attempt mediation. The guidance then explains what a child arrangements order is. It's to decide where your child lives and when your child spends time with each parent. Now, I've been doing this for 8 years, and the Cafcass and the courts deals with these issues very effectively and entirely independently of any solicitors. There's actually very little law in child arrangements, and it basically evolves around nothing more than trying to sort out parenting disagreements. Cafcass and the courts apply a framework called the Child Welfare Checklist to look at the issues only from the eyes of the child. They're not really interested in the parents' narratives, and Cafcass won't even talk to your solicitor. The guidance then explains how to apply using the form C100 and C1A, and of course you can now apply for these online. And even the other day, member of the public came through to our website and said they've been quoted again £750 for a solicitor to complete their C100. £750 is a disgrace. We will help you complete your online application for £50. If you haven't yet attended a MIAM, we will guide you to getting that MIAM certificate, and that will be a total of £75. So either £50 if you've got the MIAM certificate or £75 if you haven't. And we will then help you complete your entire application and submit it to the court. £750 solicitors are charging. The government guidance then explains what happens after you apply for a court order. At the hearing, a judge or magistrate will try and work out what you can agree, what you cannot agree, if your child is at risk in any way, and they'll encourage you to reach an agreement if it's in the child's best interest to do so. And again, that's what the Cafcass and the courts do really well. It doesn't involve your solicitor. You don't need a solicitor. Cafcass won't even talk to your solicitor. If you need some guidance through the process, someone to go to court or to be on a remote hearing with you to help you, support you, give you guidance, then as McKenzie Friends, as lay people, we can do that at an absolute fraction of the cost. Now, interestingly, when you go to a meeting with Cafcass, if it's a one-to-one meeting, Cafcass won't talk to your solicitors. They'll only speak with you. But as McKenzie Friends, we can be present while solicitors can't. A solicitor is stuck in a corridor, sitting on a chair, but we can go in with our clients because Cafcass can't insist that a service user goes in on their own without a friend being present, and we are that friend. The guidance then goes on to say if you cannot agree at the first court hearing, the judge or magistrate will set a timetable for what happens next. They might ask you to try again to reach an agreement, for example, by going to a meeting with a mediator. It doesn't say go and get your solicitors to try and take chunks out of each other. It says go to mediation. It explains to you what the Cafcass reports are. The court can ask Cafcass to provide a report on the case to help you decide what's best for the children. Cafcass officer may ask your child about their feelings, and you'll get a copy of the report when written. Cafcass may come and speak to you. They may speak to your children. They don't speak to your solicitor. So I'm baffled as to why people are paying thousands, if not at times £10,000 for a legal representation when there's absolutely no need to have them in this process whatsoever. Now, the final hearing, the judges and magistrates may consider what's known as a child welfare checklist. And all they are is a framework which they put around any decision that they have to make in relation to children. For example, the child's wishes and feelings, the child's age, gender, and any characteristics, possible risk of harm to the child, and the ability of parents to meet the child's needs. There's a few more, but you can look at those for yourself. Again, there's very little legal about this. Child arrangements are simply about disagreements between two adults where the court will intervene. They don't take sides. They look at how to resolve these disagreements from the perspective of the child. It's not a contest between two parents when you need solicitors arguing on their parents' behalf. Solicitors like to make you think it is, but the court system isn't that way and has never been that way. In my opinion, having solicitors is a complete and total waste of money, and you might as well place it on a bonfire. See, the whole family court system is built on a process that does not require solicitors to act on the behalf of parents. It is almost like a conveyor belt where Cafcass and the courts manage the issues. From my experience, solicitors achieve absolutely nothing, and there is no advantage to having a solicitor at all. But as McKenzie Friends, what we can do is to support and mentor you through the process as non-legal entities, as friends. We can guide you and explain to you every step of the journey and to assist you with all the documents and statements. Tens of thousands of people are now realising this and self-litigating through the family court system. And the myth that the family courts need solicitors is now well and truly busted. So don't spend thousands, if not tens of thousands of pounds on solicitors. Don't get into lifelong crippling debt through loans and credit cards. Do your children a favour and save that money for their future education. They'll love you for that.